YouTube, it's Tom back with another one for you, and this one here is interesting. As we get further down, this is a continuation of creditors and their bonds. This is number 7. So, and as we get down, you're gonna start to see, they kind of touch on the basics in the beginning, and then as we go through the document, you're gonna see things get a little more escalated as to how things move, and then how you should probably move, like throughout the trial, or like not even the trial, just what they call the information process, which is another word for the affidavits and shit like that, right? So let's get into this here. Here it says, here's a different scenario where the man does not participate. An investigator from ABC agency, whatever the agency's name is a municipal corporation, has filed an information. Information is like another word for affidavit or some shit. With a prosecuting attorney. Before things get this far, you should have completed an administrative procedure on the activity that is the subject matter of the court case. See the section on administrative process. The prosecuting attorney has decided to commence an action. The action creates a new trust to be the accused on the complaint or indictment, which is a charging instrument too, mind you, right? So when you understand the A4V process, acceptance for value, the indictment is going to be the original charging instrument, which would essentially serve as the bill or the truest bill that they have, right? So, I mean, a true bill is going to be what the commercial value of the charges or the fucking indictment is, which is delivered into your hands. This time you accept the presentment for value, return it, and authorize the use of your credit and the bond in the case. You give notice to the public and these private actions that you have taken. You use third parties to testify to the agreement of the parties of the dishonor of the plaintiff if necessary. So you can bring the state in to testify on your behalf. The state is you. The state is the people that you bring. That is the state. Otherwise, you have corporations pretending to be authorized representatives for the state. Right, everybody's in there arguing as authorized representative for fictional bullshit, for things that don't fucking exist, right? And nobody is the state. You can't go in there and be like, oh, well, can the state please stand and raise his hand to give his name for the record? No, the fucking state can't do that. All you have is a bunch of authorized representatives, essentially representing different corporations, claiming to be representing something that doesn't fucking exist. This is what's happening in there. So you can bond the case. You do not have to be the trustee and represent the accused trust to take the responsibility for the presumed violations of the state statutes. You are one of the people. You are the creditor with priority over the fictions. You are the one. One is the anagram of Neo, mind you, right? The Matrix. You are the one. Neo, Matrix. The one who has the power to create and win situations for all parties. Creator. The prosecuting attorney is still the creator. Yeah, right, nigga, he created a fiction. So trust name. The name of the trust is still all caps, John Henry Doe, truster. The prosecuting attorney is still putting the charge into the trust as a corpus. A corpus is a dead entity. It's a corporate entity. Corpus. I mean, you know what a corpse is. A corpse is a dead body. A corpus is just another fucking example of that, right? A corporation is a dead entity. So beneficiary. The beneficiary is still the state of whatever your state of. Whatever state is supposedly charging you. Trustee. Since you have not volunteered to be the trustee, the prosecuting attorney is still the responsible party. You are the one who accepted delivery of the complaint that was sent to the trust over which you are presumed to be the trustee. If you can stay in honor when you take the obligations of the trust by using your exemption and your credit as surety of the trust, you will be fine, right? So you can argue with the attorneys and the judge and the witness and the clerk showing how bad a trustee you are, or you can accept the state's request for revenue and authorize the use of your exemption. It's your choice, right? And so if you ever went in there, you're going to go in there and speak on behalf of. So I would go in there as the authorized representative of the defendant, which is the fucking piece of paper, right? And I would be in there for a special appearance for the purpose of settlement and closure of the accounts, and I would go ahead and order the court to use my exemption to settle the matter and close the account. Surety. The suretyship on this case can be shared. Suretyship is a voluntary act. You can volunteer to be the surety using your exemption or credit. Someone else can volunteer to dishonor someone or to dishonor the process, thereby becoming the surety. You don't want to argue with these fucking people because then they know that you're an idiot. You go in there arguing, they're going to be like, bro, this dude's arguing about some shit that doesn't fucking exist. This is all an act. It's a fucking play for them to try to get revenue. Free will is always the factor here. The big question is, who will be the surety? Since there seldom is a bond in the case until after the trial's over, you can present your bond, so you can bond the case, right? Plaintiff, whoever bonds the case is the plaintiff. Charges, right? So you bond the case, you become the creditor, and you become the plaintiff, and you can go ahead and move to close the case at that point once you bond it. Charges cannot be brought unless there is a bond. If the man supplies the bond, the man is the creditor. The table's concerned. You can do a counterclaim by removing cases into another court for judicial review of your administrative process and get a estoppel on their case. Right? You should already have one of these anyway. You should have a promissory estoppel, which is one of the services that I actually offer. And this is all done through notary, and this puts them all on notice as to your position prior to any issues coming about. And so this way you have your fee schedule included in there. You have all your private property in there. You have your children in there, your fucking car, your house. All that shit is already on a promissory estoppel, which is served to all the key agents that are in your state prior to any issues ever coming about. So if you were ever to get some, like one of these offers in the mail, which they call a summons, it's really an offer, you can go ahead and reject that and send that back with a copy of your estoppel, which you already have on file, which states your fee schedule and all that. And at that point, so it's basically a counter offer. They would send you a summons. That's an offer. You would give them a counter offer with your fee schedule and all that. And if they decide to move forward at that point, they're going to have to pay you prior to any fucking actions moving forward, right? It's all a fucking game. Defendant. The prosecuting attorney is the defendant, unless there is a defense attorney who has put a notice of appearance into the case. If so, the defense attorney is the defendant. As the creditor, you can authorize the prosecuting attorney or defense attorney, if he has filed the notice of appearance, to write a check to settle the account. The check is backed by your bond, right? So you can authorize them to use your credit if you want. It's up to you. It depends if you think that they're even worthy of the money. If they come at you sideways, why the fuck would you let them get that money? You know what I'm saying? Don't come at me crazy and think that we're just gonna play your fucking game. Absolutely not. You come at me in a fucking dishonorable fashion, guess what you're gonna get back? I'm gonna accept your fucking disrespect for honor, and I'm gonna fucking return your disrespect with some more fucking disrespect. Really that simple. Don't come at me stupid. Don't come at me stupid. So here we have the administrative process. This is a hypothetical situation. A few months ago, ABC agencies sent the all capital letter name John Doe Trust and administrative presentment, which is an offer, with a charge, right? A charge is energy. You know, when you charge a battery and shit like that. So when something charges, they're essentially they're giving you the power. They're charging you with the energy, and you can discharge that. That's what a discharge is. When you discharge your bills, mortgage, all that, of $5,000. It wants or needs $5,000. You are the source. You are the banker. If you don't give it to them, they will use your dishonor to support a claim to the $5,000 worth of the trust property. You accepted it for access value and returned it, gave them the authorization to use your credit. Exchange your exemption for the discharge of the charge. Your acceptance is the return of energy. They received your authorization, which may have been a bill of exchange, a bond for discharge, or other instrument that you chose to use. Now, ABC has hired an attorney to bring charges into the public court against John Doe, which is your all caps. A summons and complaint was delivered into your hands today. What do you do? These are all offers. You have 72 hours from when you receive the offer to accept it or fucking reject it, all right? Because this is all contract law. This is going to fall under the UCC, under the 72-day rule, the 3-day rule. 1, realize first you are in the courtroom on your case. John Henry Doe, you have removed ABC's case to the different court by filing an amendment complaint requesting judicial review of your administrative process. The purpose of this case is to get the public order that will overcome the claims being made in ABC agency against John Doe, which is your all caps. You have to introduce evidence into the judge's file to give him facts upon which he can base his decision. If you are asking for finding of facts, he must have some facts in the evidence file. You don't want the respondent to enter evidence and have his be the only evidence upon which the judge will base his decision. And that's the biggest thing too, is that you have to get in the habit of returning their fucking disrespectful bullshit with your factual, lawful standing, right? So get in the habit of filing your affidavits. If you need the common law abatement package, send me an email. It's just free. I'll send it right to you. It has affidavits in there and all that, right? So you can fucking attack their bullshit from jump, even just attacking their use of the language, which is not in common English, and then I take it from there. And there's a whole bunch of affidavits in there. So you want conclusions of law. He must have some law in the evidence file. The only way facts and law get into evidence, the one that the judge keeps in his possession, the clerk's file, you have to introduce it into the open court. County recorder, county assessor, notary public, and other public officer to the bailiff or judges, who will then hand it over to the judge. And so when you have something notarized, it's private until you have it notarized. So a notary public, when you have the notary public notarize any of your documentation, it is now valid in the public, and a notary has, which is a magistrate, has moved it on into the public, which will now it'll be able to be placed on the record in the public. Notary public makes it public. So have a copy for the attorney also. You do not want this if there is a public defender. You have to introduce some law that supports your request into the record to give him something which to make the conclusions of law, putting this into the complaint as an exhibit and filing it with the clerk and giving it notice to the respondent does not get it to the judge's file, right? So you definitely have to get that file with the clerk, have them stamp it, and you take a certified copy back with you, and they do certified copies and shit. Right, so and we shouldn't have to pay for all this because access to the courts is all free, but you can get that back. Just go ahead, put on your credit card, you can get that shit back anyway. You can discharge that. So more on this part of the administrative process later in the section. You need evidence and fact at law. What do you want the judge to do? This is the time before you even do your administrative process to decide what you want the evidence, what you want, and what evidence you will need to support what you want the judge in ABC's court case and judge to, in your removed case, to review the administrative process and issue order confirming the facts contained in the notary's certificate of dishonor or certificate of breach, right? The breach of trust and all that, because they have a fucking fiduciary duty to, what do you call it? To administrate your trust in the way that best fits you being the beneficiary. So that is certainly a breach of certificate of non-response, whichever is appropriate for the situation. Even if you do not quote statutes, the notary certificate is recognized as prima facie evidence and the facts contained therein. Look at the commercial statutes for your state. The UCC source is 1-202, OCGA statute 11-1202. Since your administrative process will result in a certificate, this is the time to decide what you want from the one that sent the presentment of the straw. Put the horse in front of the car, or you may find that the certificate did not contain the exact wording you want to use in the certificate. This freaking font is tiny. It cannot be changed after the fact because the notary could be accused of making legal determinations or practicing law. Do not put your notaries in jeopardy. And this is why, you should definitely go, like I always go to the state notaries, and then so we get the state stamps and all that on it, and they don't usually argue. You know what I'm saying? I mean, the notaries certainly don't argue. Their only job is to make sure that it is you signing the fucking paper, and they take your testimony at that point. So they never argue, and then when the courts get your documents and it's stamped out of state, they just go ahead and move forward with whatever it is that you wanted them to do, because they're really waiting on your fucking direction. It's not you going there to see what the fuck that they want to do. These are your servants. You have to know how to fucking direct them and use them to your benefit, right? They're not always there to hurt you, but a lot of them are trained improperly as well. They don't even know what their actual fucking position is, what their title is, and how they should be operating. All right. So it is a game of chess. Stop playing checkers with these fucking assholes. That's what I got for you for now. Until we meet again.